I didn't want to interrupt the speaker when they said that the fresh disqualification notices after the new speaker took over were not issued for 8 months. Because during that hearing in the Supreme Court, everyone decided that while your lordships are seized of the matter, the speaker would not precipitate the matters or proceed further. So to say that he did not act on those notices is completely incorrect, because that was something which was agreed to by the parties. What was not agreed to by the parties was TC being injuncted, which your lordships decided. But the other issue was, when we all were here, we all were ad idem on the fact, let it not be precipitated. It's a very wrong impression being given as if the speaker has been sitting and not even issued notices after that.
Because he issued notices against us. He said, issued notices despite what my learned friend is saying. So what's the point of this kind of interjection? He selectively issued notices. There was no bar as far as he is concerned to issue notice to us. But there's a bar as far as notice to their own people. What kind of intervention is that?
To both the
anyway, one second.
Both parties.
Now let's, Mr. Sibal, for a moment, we're not clouding our mind on the correctness of Nabam, on the facts of this case. That would be a very improper. We must look at it straight on as a constitutional issue.
Yes, I agree, Manoj. I'm only saying, yes, absolutely.
What is worrying on the other hand is this. He's just putting it to you. On the other hand, if you say that, well, he can take all action, including on deciding on disqualification, until the motion is put, the day is put to vote, the consequence then may also be this, that he can affect the motion for his own removal by deciding upon the disqualification.
I tell you, Lordships,
That's so desirable.
No, I tell you, Lordships, there's a difference there. His removal by the House, not subject matter to challenge. It's a legislative process. Internal to the House. A disqualification in the same schedule, subject matter of challenge. Judicial.
Person is wrongly disqualified.
If person is wrongly disqualified, your lordships have so often interfered. Set it aside, you can go back.
But of course, therefore, then we'll also have to factor in. Of your submission is that though a speaker then can, by deciding upon the disqualification issue, essentially affect the course of his own removal.
No, that is your lordships are assuming that he will discharge his functions in a malified degree. Your lordships may have to take that constitutional assumption. And the whole purpose of Kyoto Holohan.
Ultimately, that was the whole basis of your initial submission.
No. Because I am being a arbiter in these matters at all. So that's another matter. That's nothing to do with it.
The other thing which seems to have hit the court is that's really, otherwise constitutionally your argument is, obviously, prima facie. Your argument on reading 179 and 181 are very clear. So this, at least 14 days notice of the resolution is given, is now regulated by the rules of procedure, which says first 14 days of the notice.
Yes.
Then the leave is to be granted.
Right.
And thereafter 7 days, a period of not more than 7.
But some problem may arise. For example, nowadays, we see diminishing meetings of sessions in Parliament and in the assemblies. Budget session sometimes in some state assemblies is only 5 days or only 7 days. So where do you get the 14-day notice? That's the other problem. We have to look at it, the ground realities. The Constitution says 14 days notice because the Constitution makers never imagined that we will make the assemblies redundant by not meeting at all. But the whole process has been polluted now. We never thought. I'm not saying now. I make no political arguments in court. I've said all governments. Remember, I made all those views all over. So there's no politics in this. This is for the country, for democracy. This is not for A or B. We come to power, some other party comes to power, they'll misuse it. They'll misuse it to your disadvantage. So let's not get into that.
Read 181.
In this case, even the 11th position has not reached your argument.
Yes. And this is what is happening, so you won't get the 14-day notice. So then how will you remove him? Now, if you have the 14 days notice, even if it is earlier, then you can't say he's disqualified.
Second proviso, it's a very interesting proviso.
Yes.
Provided further that whenever the assembly is dissolved, The Speaker shall not vacate his office until immediately before the first meeting of the Assembly after the dissolution.
That's correct. It's a continuing. It's a continuum.
The Speaker continues notwithstanding the fact that he was elected through the Assembly.
That's correct.
Until the new Assembly takes place.
Even in dissolution.
Even in dissolution.
Then what happens is that the Speaker vacates his office in the next session when it is reconvenes.
The pro tem Speaker.
And then the pro tem Speaker, the oldest member of the House normally, is then retired over them.
This was relied on by Venkatachalaya to uphold the position of a Speaker, saying that he has got nothing to do with the political party, his objectivity is there, despite the House Speaker continues. So therefore, we can trust the Speaker as the arbiter. That's
we've seen that trust, we've seen that trust being used and
was rejected.
Mr. Nariman and my argument was this is unconstitutional, don't give it to the Speaker. But because it was rejected, 3-2. But I think the time has come when you're not. I really think so, because this is not about this case alone. These are quintessential questions which will, on the basis of which democracy will survive. Otherwise,
then give it to the Speaker, then who will decide?
The court.
Why should the court?
It's a matter for the House. That argument was also rejected.
That is exactly what Justice Sibal says in Judicial.
Was that we court should not, because it was argued saying that court can't get into the House to decide.
And ultimately, if you say that this is unconstitutional, then you completely throw the baby out with the bathwater.
Yeah,
there is no disqualification.
Well, there is no bathwater left at the moment.
It's an endeavor of
the civil. Otherwise, if you say that, well, the entirety of it goes, then there is no provision for disqualification.
That Parliament will have to make one. The Parliament wants to deal with morality in politics, they will have to make this. This has to be done. Now, how we make it, what is the contours of that legislation?
You don't have to go to the extreme of the yeah.
No, I'm not. I'm only saying, brother, I'm only saying to your lordships that this is the...
Let's draw a line there, Mr. Sibal, or else it will become unending.
It will become unending. And there has to be some constitutional certainty also. I mean,
but then you must lay down a law, that there is some certainty, because otherwise, what is happening is, that these matters are never heard. Your lordship knows adjournments are granted every week, for years. For years, these matters are not heard because the Speaker is sitting there. And we come to court and the court doesn't...
But therefore, your argument on Nabam really is that the constitutional scheme does not contemplate the disqualification of the Speaker merely on the issuance of a notice, or for that matter, even upon the grant of leave.
That's right. That's right. 189 says that if there is equality of votes, then the casting vote is with the Speaker. But when his resolution for his removal is in consideration, he can only vote.
Now, when do the words under consideration kick in?
Kick in at the time when the motion is moved for consideration.
Is that so, or does it kick in the moment leave is granted to move a resolution by 29?
No. But the resolution may not be moved, as I said. No.
Still remains under consideration.
Yeah. Because then he can't be the Speaker, mother. Then how can he sit on that chair?
And how can he? No, he can't be the Speaker in the meeting, correct? Or the day on which the actual resolution is taken into consideration.
Yes.
Taken up for consideration.
Absolutely.
That is what you are submitting.
That's right.
Otherwise, under Rule 11, he cannot act.
Because otherwise he can't act, grant leave. He has to be
Interestingly, both Clause 2 and Clause 1 is the expression under consideration.
Yes.
Now, conceivably, the word under consideration in Clause 1, the words under consideration in Clause 1 may not only be relatable to the date on which the resolution is taken up for consideration.
That's right.
In Clause 1. But in Clause 2, it is obvious that the words under consideration operate on the date when it is actually taken up for debate.
That's right.
So the question is whether we should therefore expand Clause 1 and say that under consideration in Clause 2 relates to a different point of time than in Clause 1. That's a possibility.
Well, it's my respectful...
According to you, should mean the same.
I'll tell your lordships why. The word consideration is not a word of art in Clause 1. It is a word which relates to the procedure of the heart. It's not a word of art.
Because
Under consideration.
says that you have a right, he has a right to speak when it is under consideration.
Yes.
Now, his right to speak is on the motion when it is.
That's correct.
Therefore, according to under 1, where he is not entitled to preside, this will attach on the date when the motion is taken.
The reason is, Manas, the word consideration is used in the context of procedure when his removal is being considered.
So, according to you, therefore, even when leave is granted, the stage of the threshold of leave is crossed, even then he can really preside.
Allahabad judgment.
There's a judgment, Manas, of the Allahabad High Court to that effect, which I showed you, Lord.
It goes with the word sitting.
It goes with the word sitting, Manas.
Is this scheme of 179 and 181 any manner affected by the 10th schedule?
No. This is our case, Manas. It can never be. These are proceedings in the House. These are legislative proceedings in the House.
The 10th schedule is silent on what happens when there is a notice.
It can't, Manas. In fact, the 10th schedule, there can be no pause, Manas, because it's a constitutional authority.
In fact,
There can be no higher, as I said, Manas, that's the base. It's a fundamental principle of constitutional law, whether it's the Election Commission, the government, the Speaker, Manas, the courts, there can never be a pause. It's anathema to constitutional.
Relating to the presiding officer of the tribunal's competency.
Yes.
They only relate to those two.
Yes.
So 10th schedule to that extent will have no bearing.
Doesn't apply. Because it's in the House. We're talking about his removal from the House.
Presiding officer. It's about his.
The flip side, if we permit a speaker, now you are assisting the court as counsel.
Yes.
Not really.
Yes, of course.
Because we are looking now at a broader constitutional issue. What would be the consequence if we allow a speaker to participate? There are two stages, right? One, just the notice. The notice is, of course, it can be given even by one person. What would be the consequence if we don't allow the speaker to take action the moment a notice of resolution is issued? That, according to you, would result in a very serious consequence. But on the flip side, what would be the consequence if we allow the speaker to participate even when the stage of, say, the grant of leave is crossed? What would be the argument on the flip side?
No, but there have to be 29 members have to support that. He cannot decide.
No, 29 persons MLAs have already supported and the leave is granted.
If they've supported others and leave is granted.
Correct.
Mr. Chief is my brother will explain what was falling.
Was asking you is what will be the consequence of the speaker continuing to decide the 10th schedule proceedings while a proceeding is pending after issuance of the notice?
As I said,
that's the question.
Yes, as I said.
Other line of this should be seen in the context of other line of judgments under 10th schedule, saying why is he in such a hurry to decide? There must be sufficient time.
Let me answer that straightaway, Now, you are interpreting 179 to mean that the speaker will continue to discharge his functions as a speaker till the motion for his removal is put to vote. The purpose of
Correct.
He has no disability. Correct. And till it is put to vote, the motion will never be moved. Will never be moved, Malak.
So, Mr. Sibal, what is worrying me, of course, is sorry, Nasma.
No, go ahead.
Now the only point is this, that by giving the power to a speaker, are we then going to essentially give the speaker the ultimate power to decide upon the course of his own removal?
No, it's not the course of his own removal, the course of the removal of those who have actually voluntarily given up membership of the party. This is not a question of course of his own removal.
Yeah, that's because
he will tilt the balance.
I'm sorry?
That may tilt the balance.
But it will balance. If they have voluntarily given up, it will tilt the balance. Why should it not tilt the balance?
Decided.
Why should it not tilt the balance? If actually, kindly forget about, now let's go into just a short summary of facts. In this case, what happens? In this case, what happens is this notice is given. This court says they can reply by 12th of July.
Right.
And the government falls in the meantime. And we are 8 months down the road. He has not even given notice on our disqualification petitions.
Move the notice.
No, the person has not moved the notice and the speaker has not given a notice on disqualification petitions.
Taking from the
I mean, you have seen the...
So according to you, the speaker was well within his right to disqualify anybody in the meantime as well?
Because of the facts which are undisputed. You had a new government with the support of these people. What else is it but voluntarily giving up membership of the party? And then, Manoj, if the argument is he is going to decide his own fate, no.
Now, Mr. Sibal, we saw the first part of Nabam Rebia where Justice Kher puts it as a matter of ethical grounds. Now, how does he interpret?
Yes, I was going to read that.
Well, let's just
we'll go
so
for
that's the next step
Yes.
to cross on Nabam.
Yes, absolutely.